Good morning, everybody. My name is Judge Peach. To my right is Judge Bartley. To my left is Judge Fell. Today we are here to hear the case of Luann Wolfe versus Robert L. Wilkie, Secretary of the Veterans Affairs, docket number 17-519. The issue on appeal before the court is, what circumstances would allow this court to exercise jurisdiction over a chairman's denial of a motion for reconsideration pursuant to 38 CFR section 20.1000, which has been redesignated as of February of this year as 20.1001. Would counsel for each party please note your appearance for the record?
I'm Harold Hoffman for Luann Wolfe, and to my left is Megan Gentile, also for Luann Wolfe.
Thank you.
Good morning. Joshua Walensky on behalf of the Secretary, and with me at counsel's table is Ken Walsh.
Thank you. Does counsel for the appellant wish to reserve time for rebuttal?
Yes, Your Honor. We're reserving 10 minutes.
10 minutes. Thank you. Okay, you may begin when ready.
May it please the court. Luann Wolfe is a victim of fraud. She was tricked into believing that her husband, Ronald Wolfe, was married to Rhonda Matthews. The board relied on that fraud to deny her DIC. Mrs. Wolfe asked for reconsideration, and in support of her motion, submitted an Oklahoma court order that proved Rhonda Matthews' fraud. The board chair acknowledged that fraud, but refused to reconsider. The board chair did not review the Oklahoma court order to determine if reconsideration was justified. That's because the Secretary's position is that Rule 1000A operates the same as Q. Secretary also believes that the board can only take away benefits due to fraud, but not grant them. Discovery that the board denied benefits due to fraud is a changed circumstance that requires reconsideration. Rule 1000 provides 3 examples of changed circumstances that warrant reconsideration: obvious error in fact or law, new and material service records, or when an allowance of benefits is due to fraud. This court held in Ingolka and McCall that list is not exhaustive. The question in this case is specifically whether evidence of fraud is a changed circumstance that requires reconsideration.
Excuse me, now, why do you say that in Gelke, the court said that it was not an exhaustive list?
Because in Ingolka, the holding was that the type of changed circumstances that would lead this court to take jurisdiction over a denial of reconsideration are those that are rooted in Rule 1000. Rooted in means to be similar to. In explaining its holding, this court said that the type of changed circumstances have to be of the variety. The court then said that, for example, obvious error, new government records, or fraud. The court said all of that, Your Honor, after discussing McCall and finding that McCall's holding was that not an allegation of obvious error, but an admission to errors in the Secretary's previous board decision was a changed circumstance that warranted reconsideration, and that this court would take jurisdiction to review the denial of. The VA already reconsiders obvious errors, including when they become obvious due to fraud. In the non-adversarial system, the Secretary has taken the most adversarial position possible, that he will reconsider decisions that result in a grant of benefits due to fraud, but refuse to reconsider any decision that results in a denial of benefits due to fraud. Like in McCall, a changed circumstance was found because it was similar to Rule 1000A, an obvious error. But in McCall, it was the Secretary's admission to an obvious error. Here, we have an obvious error. But it's not just an allegation, but there's proof of the obvious error. Furthermore, we don't have an allowance of benefits due to fraud. We have a disallowance of benefits due to fraud. And in the non-adversarial system, that denial has to be reconsidered.
Now, just getting back to Engelke and your statement that it held that circumstances other than the ones listed in the reg could be a basis for recon. When there's language in a reg, haven't we generally held that when there's language that's kind of broad, like including or including but not limited to or something like that, or other grammatical terms that would indicate that this isn't limited to those circumstances? Haven't we always had that in the past? Something that indicates that these circumstances are not limited to what's listed?
Yes, Your Honor. Rule 904 explicitly says that the board will vacate a decision when there is a due process violation, and then the language says something of the sort that examples of due process violations that will cause us to vacate a board decision are, and it goes through A, B, and C.
And so the absence of some language like that would lead to a broader interpretation, why wouldn't we require that here?
With, for instance, Rule 1000C, if the language is strictly read and that's how the court is going to read it, then the regulation itself, at least 1000C, would be unlawful. There's no justification.
Unlawful?
It would be an unlawful interpretation of 38 U.S.C. 7103, Your Honor.
Or abuse of discretion or arbitrary, but you're saying it would be actually unlawful contrary to the statute?
It would be contrary to other statutes and VA's intent to be non-adversarial and proclaiming, Your Honor.
I'm sorry, I interrupted you. Go on.
Protecting the public, the Secretary argues that taking away benefits due to fraud accomplishes a very important government goal, which is to protect the public fisc and to protect the VA's integrity. And we agree, it does that. But it would still do that and also do more in allowing the Secretary to meet his other worthy goals, which are to ensure justice and ensure that benefits are paid to the claimants they are due to. If the Secretary reconsidered all decisions that were the products of fraud. Protecting the public fisc does not mean to deny all claims. Protecting the public fisc means that the Secretary should pay benefits to claimants that are entitled to them. The VA should repair all decisions that are products of fraud. Proof that benefits denied due to fraud requires the board to reconsider under Rule 1000A because it proves that the old decision, the decision being reconsidered, is a changed circumstance because that fraud proves that that evidence at the time of the board decision was wrong. Even if it isn't a changed circumstance under Rule 1000A, the law requires that it is a changed circumstance under Rule 1000C. It is of the type found in Rule 1000C. It's very similar. The only difference being it's a disallowance of benefits instead of an allowance. Moreover, Rule 1000C has to be interpreted in a way that allows the VA to reconsider whenever there is even a denial of benefits due to fraud because of the non-adversarial system.
But you're making a case that it's of the type of, it's like fraud, similar to fraud. Yet there's a big distinction here. The fraud that is remedied by C is fraud on the agency. Yet here the fraud, if anything was fraud on the Texas government, not even a Texas court, whoever issued the original Texas marriage license. So there's a distinction between those. It's not just a question of protecting the public fisc, but protecting the integrity of the process, the VA process. Is that not a distinction?
I agree that's a
It could be important to the Secretary?
I don't think it's an important distinction, Your Honor. If the fraud is committed on the Texas court, and that was its intent, the VA, as much as Mrs. Wolfe, is currently a victim of that fraud. That fraud has perpetrated from 2001 until right now, as we're sitting here. It's caused the VA to not be able to, or the Secretary not to be able to fulfill his most important task, which is to ensure that benefits are paid to those claimants that are entitled to them. So the VA is a victim of fraud as much as Mrs. Wolfe is. If VA's goal truly isn't to win cases, but is to administer benefits fairly. The court should hold that the Rule 1000 list is not exhaustive, as it did in Ngolka and McCall. Hold that a disallowance of benefits due to fraud has to be reconsidered in all situations. Find that the board's reliance on fraud requires reconsideration under Rule 1000, and find that the chair abused her discretion by not reconsidering benefits denied because of fraud.
The use of the terminology of the variety in Engelke, do you have any authority interpreting consistent with your theory that of the variety should be read as, for example, or such as, or one of the terminologies that's used in regulations or statutes to say that's a non-exhaustive list?
Yes, Your Honor. This isn't from regulation or statute. It's from Merriam-Webster and Cambridge, which they agree, as will every other dictionary we looked at agrees. Of the variety means to be among a group of things that share general features but differ in some details. Rooted in means to have developed from something and be strongly influenced by it. Of the sort means to be similar to something. And e.g. in the parenthetical means, for example. So I think there were three opportunities that this court in Ngolka, Your Honor, could have said the type of change circumstance has to be those found in Rule 1000. But the court declined to do so 3 times and instead qualified it with rooted in, of the variety, and e.g.
Now, go ahead.
And you're saying that you're going to hang your hat on the third one regarding the fraud.
Your Honor, I don't know that we have to hang our hat on any, but I think that it's most like 1000C, Ms. Wolfe's situation. However, we also think that it fits well in Rule 1000A, because that fraud, we know, did result in a denial of benefits. It changed I think the Secretary says it perfectly on page 21 of his brief. That Oklahoma court order fundamentally changed the evidence that was before the board in 2014. And the VA granted, when she moved for reconsideration, she also moved to reopen her claim at the regional office, and it was granted almost immediately.
What does that argue for a new and material evidence consideration by the agency first rather than this court?
No, Your Honor. The new material evidence.
It's after the board, right? It's not.
Yes, Your Honor. The fraud was not discovered until after the board's decision. Lou Ann Wolfe knew her husband, Your Honor, was not married to Rhonda Matthews, but she didn't know that she was a victim of fraud until the Oklahoma court order that came, I think, 6 months after the board's decision. That is why it's a claim that's reconsideration rather than just a new and material evidence, because it specifically deals with fraud. And that fraud is evidence that the evidence the board relied on in 2014 was false. That 2014 decision only happened because there was no proof yet at that point that the divorce decree that the board relied on to deny benefits was fraudulent.
So if the regulation says instead that and consistent with Engelke, says the board may reconsider if it is bananas, apples, or oranges. And then Engelke comes along and says it's got to be of the variety, bananas, apples, and oranges, or oranges. We should read that to say that it does not need to be a banana, apple, or orange. It's just got to be a fruit, because that's of the variety discussed in the regulation.
I think it'd have to be a little more specific, Your Honor, where it would have to be that it's like an apple.
Okay.
So an apple, and so maybe a fruit is like an apple, but in what ways?
It's not a banana, or it's not an orange, because it's not fraud resulting in the grant of benefits, but it's a tangerine. It's not obvious error or new material evidence, but it's a pear. It's kind of like an apple. You eat it in your hand, it's got seeds in the middle. And
I think what would have to happen then is that this court would be to look at the qualities of the tangerine and the orange and see if they're similar in a way that would warrant reconsideration. So for instance, the question would be, what is similar between an allowance of benefits, or why is it reconsideration due to fraud rather than new and material evidence in a reopened claim? And I think if the court runs down the list, 1000 A through C, what is discovered is that in each instance, the evidence necessary to either win or lose or deny or grant benefits at the time of the decision being reconsidered, it wasn't available. And it wasn't available even though the VA or the veteran had developed the evidence at that time to its potential. There are certain ways that evidence doesn't just add to the record like they do in a reopened claim, but they fundamentally change the evidence that led to the decision.
No, two things, and one of them perhaps is self-evident, but I just want to hear you say it. You mention on pages 1 and 5 of your brief, and then also in your conclusion, that you're appealing the May 2014 board decision as well as the denial of recon. You don't seem in your briefing to make any argument about the underlying board decision. That was purposeful. You do not want, you don't want this court to address that, even though that provides us a broader basis of review.
It's correct, Your Honor, that we did not provide a merits argument on the board's 2014 decision. At the time, we thought we should say that so that the court would know that they have jurisdiction also over the denial of reconsideration if this court finds changed circumstances. The only way that we would want the 2014 board decision reviewed would be if it included the Oklahoma court order. But this court doesn't have jurisdiction to review that because that Oklahoma court order has only been in front of the chairperson, never in front of the board. And so this court's review of that document is limited to determine whether this court has jurisdiction over the motion for reconsideration.
Okay, that answers my question. Also, as far as changed circumstances, and we have the locomotive engineer's case, do you have any case law that you would rely on that interprets, let's say was it the Interstate Commerce Commission rule that was at issue in locomotive engineers? Do you have any case law there that their interpretation of changed circumstances would include fraud as to either party, using that term loosely.
If we go away from locomotive engineers, Your Honor, I think the best case starts getting into like Hazel Atlas Glass Company v. Hartford Empire, and we go back to Supreme Court cases where the Supreme Court warns that products of fraud, Your Honor, are detrimental to American jurisprudence, and that courts should, when they can, go back and even rescind judgment when they find that their decision is a product of fraud. I know the board is not a court, but right now we're sitting here. The board knows that fraud led to its 2014 decision. The Secretary's position is, well, we didn't find out until after the board decision, so too bad. And that's not what the Supreme Court seems to be saying in Hazel Atlas Glass. There are multiple federal circuit cases. Almost every circuit has addressed when fraud has influenced a district court's decision.
Yeah, let me have you talk about that a little more. So to me, changed circumstances as well as fraud would always entail the body, let's say here the board, looking at additional information that was not of record at the time of the original decision. Do you agree with that?
Yes, Your Honor.
So that the rule itself does not contemplate, and I was kind of surprised to see in the denial of recon on page 2 some language about 20.1000B requires that new evidence submitted must be in existence at the time of the board decision. I mean, doesn't that seem a little bit odd whenever you're talking about if you're allowing recon based on fraud or based on forget about service department records, based on fraud or based on changed circumstances, wouldn't that always be something that wasn't necessarily in existence at the time of the board decision?
Yes, Your Honor. My guess is that a lot of the Secretary's position is confusing reconsideration based on new evidence with reconsideration based on changed circumstances. New evidence, for instance, those records have to be service department records. But I think that new evidence in the form of Social Security records that were uncovered could possibly fit as a changed circumstance because it's similar to Rule 1000B. But this case is about changed circumstances, not new evidence, Your Honor. So I agree with you.
Well, that's part of my confusion is that there are changed circumstances, I guess, but the regulation doesn't use that terminology, and it seems to come from the ICC versus the Board of Locomotive Engineers case, interpreting an ICC statute that used for its reconsideration provision a third type of matter that should be reconsidered or could be reconsidered, and that is changed circumstances. And then a couple cases come along here, and we begin just throwing that terminology into the analysis, where the regulation doesn't use that terminology at all. And then Engelke seems to want to walk that back a little bit and say, no, changed circumstances is at least for our purposes, is an umbrella term. It's got to be one of those three types or the variety of changed circumstances listed in the regulation. Why is that not a way for us to look at it?
I think that is how we are asking to look at it, Your Honor.
Okay. But it's not one of those types of changed circumstances. You want us to recognize a kind of sort of like changed circumstances, a tangerine, a pear.
I would agree, Your Honor, that it isn't one of those changed circumstances, but it is one of those types of changed circumstances. As types means like you're forming a world in which to look at and see if something is similar to something. Maybe it's the same, but it can be a little bit different.
Yeah, let's just clarify what you want done here, because you mention in your brief again about reversing the May 2014 board decision. So if we were to buy into your view that there was that under 20.1000, the third factor under 20.1000, the fraud, that just meant fraud generally. What are you asking for here?
In our brief, Your Honor, we asked for more than this court has jurisdiction to grant. And we realized that with the research in the last week, that if this court orders reconsideration, then that underlying board decision would be vacated. And once it's vacated, there's no final decision for this court to take jurisdiction over until the reconsideration is completed.
So you would want us to order recon, and whenever they're recon, they are going to vacate the underlying board decision before they initiate reconsideration?
Yes, Your Honor.
Okay.
Can we, I guess that draws me to the very beginning of 1001, where it says reconsideration of an appellate decision may be accorded at any time by the Board of Veterans' Appeals. Are you saying that it's required that the chairman had to order reconsideration?
Yes, Your Honor. The regulation is written.
It's not discretionary to the secretary or to the chairman?
It is discretionary, Your Honor, but the secretary is never allowed to abuse his discretion. Congress said that they want some decisions reconsidered, and the secretary does reconsider some decisions. If the secretary had pure discretion, it wouldn't be reviewable ever by this court. What we found is that the secretary will reconsider when it's 1000A, B, or C. And what we're arguing is that is an abuse of discretion. Even if the regulation is written permissively, the secretary can't reconsider in some instances, but not in others. Can't reconsider when he finds a benefit is granted due to fraud, and then refuse to reconsider when there is a denial due to fraud.
And then what's the next step after we require the chairman to reconsider, or we order the secretary, this shall be reconsidered?
When the secretary reconsiders, the board decision is vacated and a new board decision is issued. And when a new decision is issued, then this court would have review of the new reconsidered board decision.
And at that new board decision, the divorce decree or the dissolution of the marriage decree would be introduced, and we would probably never be here. Is that your hope?
I don't see another result, Your Honor.
So I'm going to add 5 minutes to your time because I have a question as well, and there may be other questions. I noticed that in the record of trial there seems to be two divorce decrees. Could you explain what that's about? I would refer you to page 425 of the record and 495 of the record.
I thought about this, Your Honor. I don't have an explanation. I asked Ms. Wolfe, and this is outside of the record. She couldn't recall why there's two either. This was before I was her attorney.
And I just want to clarify for the record, who committed in your opinion, who committed the fraud in this case?
Rhonda Matthews committed the fraud.
And she is or is not a party to any of the litigation or claim processing that went on at VA?
We don't know because the VA lost the entire claims file only about a year or two before the veteran died. I went back and tried to figure out, did he ever claim Rhonda Matthews for benefits? What I did find is some pay sheets that showed he was receiving the 100% rate for a single veteran. So I don't know if she tried to make a claim against the VA or not, because the claims file is missing. We can't even find the rating decision in which Mr. Wolfe was granted 100% service connection.
You're talking about Miss Rhonda, the alleged wife.
Yeah.
Who are you talking about? Luann or Miss Rhonda?
Rhonda Matthews committed the fraud, Your Honor. Luann Wolfe was the actual wife, Your Honor.
Okay. So it's that fraud that you believe is the crux of the matter.
Yes, Your Honor. That fraud led to Luann Wolfe and Ronald Wolfe, who were trying to tie up, and this is in the record, they're trying to tie some loose ends. They knew he was dying. And one of those loose ends was, let's get statutorily married, because of the difficulties that common law marriage can present. And this is outside of the record and from interviews with her, but just for context, when they went to go get married at the county court, the court clerk was like, "Oh, Ronald, I thought you were married to Rhonda." This was the first time Luann Wolfe and Ronald Wolfe ever had an inkling like, oh my goodness, maybe something here is wrong. They didn't know what to do. They knew they didn't have much time. So they went and got a divorce, and Ronald Wolfe divorced a woman he was never even married to. And that divorce decree, Your Honor, is what led the board to find that Luann Wolfe was not married to Ronald Wolfe for at least 1 year before he passed away, because he passed away only 3 months after the divorce.
But didn't Luann marry the veteran before the divorce decree was issued?
Yes, Your Honor. There was a statutory marriage, which is how they found out that, or heard a rumor that maybe Ronald was already married. But she had a common law marriage in Oklahoma for many years before that, the Ronald Wolfe and Luann Wolfe.
But the statutory marriage occurred before the divorce.
Yes, Your Honor.
The same Texas court that, or same office issued the second marriage license as the first?
No, Your Honor. The marriage license that Rhonda Matthews filed fraudulently was in Texas.
Right.
The marriage between Luann and Ronald Wolfe, the statutory marriage, was in Oklahoma.
Okay.
The divorce decree also comes from Oklahoma, which probably explains why they didn't know that this first marriage it wasn't real, never took place.
So how did because you said that they went in to get the marriage as they were tying up loose ends. They went to get their marriage statutorily established. They said, this is what made me think it was the same court. They said that, oh, we thought you were married to Rhonda.
This is also outside of the record, Your Honor. Ronald, Rhonda, Luann, they run in circles in these two towns of the same people, and
So these are right across the border from each other? Or?
the towns are actually not that close together, but they've known each other for years, maybe not close. They didn't know Rhonda Matthews was going around telling people she was married to Ronald, but
So this random person outside the record, this random person in the Oklahoma clerk's office just happened to know Rhonda and Luann and Mr. Wolfe and said, oh yeah, I thought you were married to.
Yes, Your Honor, actually reported specifically to Ms. Wolfe, Rhonda's been telling people at parties that Ronald and her were married.
Okay.
But that's, again, outside of the record, Your Honor.
2 more minutes.
I'm sorry.
Yeah, so how, tell me how we would write this if we were going to write in favor of your client. You make this the arbitrary and capricious argument, and it seems like it might be difficult to say it was arbitrary and capricious for the board to deny because for the reason that they did, because this circumstance isn't listed under the three as one of the three circumstances. So how would we find this was arbitrary and capricious, the denial of recon?
I think it's more, Your Honor, that it's an abuse of discretion, but arbitrary and capricious could be found in that the board, the VA, wants fraud fixed, but the VA decides when to fix that fraud and has decided based on, are we going to pay benefits or are we not going to pay benefits? And that leaves veterans at like the whim of the secretary on that particular day. Unless the court has any further questions, I will leave with one last thought, and that is the secretary's position means that he can't even reconsider a denial that is based on VA's own fraud against a veteran. Thank you.
Good morning, Your Honors, and may it please the Court. It is the Secretary's primary argument that this Court lacks jurisdiction over the December 2016 denial of board reconsideration, and therefore dismissal of appellant's appeal is warranted. Engelke v. Gober is the controlling case on this issue and is instructive for two reasons. The first is that the court in Engelke states that only new evidence in the form of Service Department records would vest this court with jurisdiction to review the denial of reconsideration. And second, because in Engelke, the court in fact limits its potential jurisdiction over denials of reconsideration and does not expand its jurisdiction over denials of reconsideration. Acceptance of appellant's argument would essentially disregard the framework for submission of new material evidence under 3.156 and essentially would require the court to rewrite the Secretary's regulation of 20.1000. Alternatively, if the court does deem it has jurisdiction, it should find that VA's rulemaking is valid and proper. 20.1000 is a reasonable interpretation of the enabling statute 38 U.S.C. 7103 and is a valid regulation. Finally, if the court reviews the merits of the December 2016 denial of board reconsideration, it should find that because there was a plausible basis in the record for the denial in May of 2014, notably that there was evidence which weighed against appellant fulfilling the one-year spousal requirement, that the denial of reconsideration was not an abuse of discretion. Moving to the Secretary's main point that Engelke v. Gober controls and should be used by this court to dismiss the appeal. At its core, Engelke reviewed evidence that was submitted after the board decision, and the court deemed that new medical evidence unable to vest this court with jurisdiction to review the denial of reconsideration. And it's at its most basic or its most reduced level that the court or that the Secretary asks this court to apply Engelke. Simply equate the new evidence in the form of the order vacating the divorce as new evidence that was submitted after the board decision that is unrelated to Service Department records. And is that central holding and that reduction that is the easiest or cleanest solution to the dispute at hand. Moreover, not only does...
So we would find, if we addressed it at all, that broad language of the variety of, things like that we were talking about with the Appellant's Counsel, we would find that was just dicta? How do we explain that more favorable, appellant favorable language in Engelke?
So to the extent, obviously it's unrelated to the central holding that only Service Department records would vest this court with jurisdiction under the auspices of a motion for reconsideration. But I think those terms are not expansive. To be talking about of the variety or something to be rooted within the regulation, it goes to what the court does do in Engelke, where it does not expand jurisdiction, it limits jurisdiction. So I think all those, for lack of a better term, the breadcrumbs in the reasoning of the variety rooted in the regulation are not expansive terms and are actually limiting language. And moreover to the point of regarding changed circumstances, I believe Judge Falvey had talked about just before in questioning Appellant's counsel. It's of the utmost importance to impress upon this court that the term changed circumstances is not naturally found in Title 38 and is not a term or a doctrine that the Secretary has used in its rules or regulations. The term changed circumstances comes from Title 49. It is specifically in reference to when reconsideration is warranted for Interstate Commerce Commission actions. It is unrelated to the administration of veterans' benefits. And so if the court were to take jurisdiction based upon that term, and again, that is not the Secretary's argument, but the court would have to reconcile with that fact, with the fact that the doctrine of changed circumstances is not a term used by Congress in Title 38 and is not a term that the Secretary has chosen to adopt. In reviewing the doctrine of changed circumstances, the Secretary argued that that argument was never directly made to the agency, and the court does have discretion to decline to entertain the argument under the Federal Circuit's case law of Majit. But again, if the court does review the changed circumstances doctrine, it should find that what Engelke does do, it limits its jurisdiction, and the terminology of the variety and then listing obvious error, government records, or fraud is reinforcing what the regulation states and is outlining the outer limits of the court's jurisdiction over board denials of reconsideration.
Let me ask you a question with respect to what Judge Falvey had asked earlier. If these three criteria, the error, the service records, and the fraud, if they were to be equated to, say, apples, bananas, and oranges, and then the question came up, well, if it's a pear, is it similar to an apple? What would your interpretation be? If it was an apple, then it's an apple, but it might be a different variety of apple, Fuji apple or a delicious apple. I mean, how do you view, what would your counter argument to that be?
Mm-hmm. So also of importance is the court's decision in Engelke comes to a conclusion and notes that the new evidence would be more ripe for a claim to reopen, and then discusses the doctrine of changed circumstances. And so, again, that language actually could be read as dicta of the variety and rooted in. But respectfully, Your Honor, with regard to what kind of fruit we're looking at, honestly, to even ask the question is what kind of fruit we're looking at, I think misses the mark in that we're using a term that's not naturally found in Title 38. And from the Secretary's perspective, we're kind of we're in a hardware store, honestly. We're not looking at similar fruits. We're looking at nuts and bolts. We're looking at an allegation of fraud committed by a third party outside the scope of any relationship with the Secretary or the administration of VA benefits. And not only that, we're also looking at a circumstance where there was not an allowance of benefits. That's a key factor in 20.1000C. It specifically states upon the allowance of benefits by fraudulent means. It's a safeguard to ensure that those who are eligible for benefits receive their benefits, but those who are not eligible for their benefits do not receive benefits they are not entitled to.
Now, I don't know how long you've been practicing veterans law, but I wanted to ask a question about something that happened, I believe, in the mid-2000s, but it could have been earlier. And that is that certain board attorneys were found to have destroyed evidence that was submitted on behalf of veterans. So veterans sent something to the board. Board attorneys, I think, destroyed the evidence or hid it. I'm forgetting exactly what. And so this goes to Appellant's counsel's question about what to do. Can VA actually do anything in those circumstances? And he was saying that under the current rule, you couldn't get reconsideration if VA employees committed fraud against a veteran. But you could, of course, as you admit, get recon when the reverse happened, that the veteran committed fraud against VA. Now, I'm wondering, do you have any knowledge of how VA, or how the board actually corrected the decisions that were affected by that destruction of evidence? If they couldn't reconsider those decisions? And I remember that there were some board letters or fast letters or something about this situation and what to do, and I'm just wondering if what happened involved reconsideration at all.
So, I'm sorry I cannot speak to the specifics of that circumstance, but I have been advised that the Secretary has addressed that circumstance, but I am unfortunately unable to give any specifics at this moment.
Okay.
Regarding those specific instances.
Well, I would appreciate some supplemental information from you about how the board actually managed to correct those decisions. I recall, as I said, VA issuances regarding those, and I think that would assist us. If in fact, my point being, if in fact VA, when it finds that something like that has happened, has undertaken to do reconsideration in these instances, that would be helpful for me to know.
If a supplemental order were to come from the court, obviously the Secretary would be happy to inquire about any questions the panel might have. But then, and also, there are also potentially circumstances where the fraud committed, obviously, Judge Bartley, the question or the circumstances where there's fabrication of evidence changes certain things, but there could be circumstances where the fraud is obvious on its face, and 20.1000A could remedy those circumstances.
Yes, I thought of that, and I'm curious as to how it was handled in these cases.
Mm-hmm. With regard to VA's enacting of 20.1000, the Secretary reads 38 U.S.C. 7103 as a intentional gap-filling measure by Congress, in that Congress did not define the term reconsideration. It provided the mechanism for who can apply for reconsideration, who can file for reconsideration, and what is to be done after reconsideration is granted. But ultimately, the term reconsideration is not defined, and there is intentional agency gap filling for that. And thus, the Secretary's regulations could only be deemed invalid if they were to be determined to be contrary to the statute or an unreasonable interpretation of congressional intent.
As far as the this issue that I raised with Appellant's counsel, the fact that the board chairman's denial of recon mentions on page 2 this that 20.1000B requires that new evidence submitted must be in existence at the time of the board decision, constructively in the board's possession. Do you have any idea of where that comes from?
To the exact language, no, Your Honor, but it is the Secretary's position that 20.1000B would only be triggered by by Service Department records being obtained. If there are no further questions, Your Honors.
So wait, are you suggesting? You started out talking about Engelke and how it added the changed circumstances language, and since then it's been in rotation. I'm not sure Engelke was the first case. I can't remember which one was. But are you suggesting that we pull back on that via a panel decision, or that we limit the bases for recon as to the 3 that are listed in 20.1000?
Your Honor, to the extent that there's any ambiguity as to what the doctrine of changed circumstances is, the court should write a rule that only allows for reconsideration to be allowed based upon the potential, the court's jurisdiction only to vest potentially on 20.1000 A, B, or C, and that changed circumstances doctrine is only those listed in the regulation. There also is the the one factor that Appellant is asking this court to review under 20.1000A, and Engelke does expressly examine that factor, and under ICC versus Locomotive, 20.1000A is actually unreviewable by this court because it would be reviewing what has already been deemed or plowed ground, and that it had already been reviewed, and that a challenge based upon A would be better suited as a challenge to the underlying board decision on the merits as opposed to a quasi-judicial review of the reconsideration.
So, as far as how we should treat the language that's used in several of our decisions about changed circumstances, what do you want us to say again? I didn't quite get that.
Ideally, that the only circumstances to which the court would have jurisdiction would be those rooted in the regulation as enumerated, and that the doctrine of changed circumstances, because it is unrelated to Title 38, is in fact needs to be clarified, and has no legal significance other than only enumerating A, B, and C, vesting this court with jurisdiction.
Now, I know that when you're arguing that, I think C in particular was geared or is geared toward protecting the public fisc. But in 1985, when VA was in the Federal Register, when VA was elaborating on that, the publication of, I think, a change in that rule, it actually said that the reason that that exists was that there was no consistent practice before the board, and that board members were handling these kinds of requests about fraud on their own. So there was, I guess, maybe some inconsistency in how different board members were handling these cases. So how does that, now you're kind of changing your tune and saying that the reason for the fraud rule is protection of the public fisc.
So to that point, the Secretary reminds the court, or impresses upon the court, that we are in the Chevron framework and that we're looking at the enabling statute and the outer limits or the discretion the Secretary has with that statute. And in making the regulation, so long as there are the worthy goals of protecting the public fisc, maintaining integrity in the veterans benefit system, or ensuring that only those who are eligible receive their benefits, that is a reasonable that's reasonable rulemaking given the statute. I understand to your question, Your Honor, Judge Bartley, looking for source documents or looking for anything that would support the regulation, but I believe that is in a regulation interpretation question as opposed to what does the enabling statute allow for. And again, the fraud does underlie the Federal Register note, and again is pivotally regarding the allowance of benefits and preventing a fraud against the government.
Could we remand for inadequate reasons or bases on this?
Your Honor, absent direct argument on the underlying board decision, that argument has been, or the argument regarding the board decision has been waived, and any specific argument has been abandoned by appellant. And so, as cited in the Secretary's brief, no, the court should decline remanding the underlying board decision on a reasons and bases basis. If there was any ambiguity to the answer, Your Honor, and if I misheard reasons and bases for the denial of reconsideration versus the board decision.
It's the board decision I was talking about. Okay. Thank you.
Yeah.
Well, do you think we would have the? Well, I guess we. Do you think we'd have the authority to remand for the on the motion, the denial of the motion? We send it back to the chairman to reconsider.
In circumstances where the regulation has been found to be invalid, the court has remanded, and that has been outside of a motion for reconsideration context. And I've seen instructions that the court has said to the board in a direct board decision, we remand and ask that the board more appropriately apply the statutory provision. Here, if that were to be done, then essentially we would also be in the same circumstance that we currently are in, because what would happen would be is that even if the court asks the chairman to reconsider, any denial of that reconsideration under A would not be reviewable by this court, and there has not been the submission of service department records. And so again, the court would be devoid of jurisdiction if the court were to deem that C somehow is invalid, or C should be more broadly interpreted. If C was invalid, then that would only leave A and B, which precludes the court's review of any denial of reconsideration.
Yeah. Mr. Hoffman can correct me if I'm wrong, but I heard him to say that that the chairman has no discretion here, that this chairman must grant reconsideration if it's any of the enumerated standards, or if it is of the variety, or like any of those. What's your response to that?
Your Honor, the regulation plainly reads, reconsideration of an appellant decision may be accorded at any time, and then provides for 3 instances of when it may be accorded.
And so that's only, that's discretionary, it sounds.
Yes, the Secretary chooses to read may as, or has promulgated the regulation on a discretion.
So if it's, at a minimum, if it's one of those 3, that would be an abuse of discretion argument if the chairman denied reconsideration, if it was squarely one of those 3. Right?
Yes, Your Honor.
And so if it is a non-exhaustive list, and then it's just a question of, for us, is it of the type in that list, right?
That would be accepting the of the variety argument, but again, there is nothing
right.
that would show that that regulation is an expansive regulation.
Okay.
There are no further questions?
I do.
Sorry, so sorry. So sorry, Your Honor.
Can you tell me whether you know or not, maybe you don't, what was the reason for in Section 1000 that the that the records be restricted to service records, and what is your definition of service records?
So that provision dates back to, I believe, the 50s. Needless to say, that portion of the regulation has been part of the regulation for quite a while, and it originally talked about either department records from, and it named the Army or the Navy. The service department records throughout VA's regulatory system or special records, they provide very important factual details of the nature of the veteran service, and because of the special and uniqueness, that has been a reason to accord reconsideration, not unlike measures in 3.156C, because of the pivotal nature of those documents.
So if the service record, say as an example, 201 file, the personnel file, if in that service file was a marriage certificate reflecting the veteran was married to his wife, and this wife is Luann, would that be considered a service record, that marriage certificate in the personnel file of the service member, which is a service record?
Your Honor, the Service Department records the Secretary would view as very narrowly coming from the armed services, and a record that was not of a service personnel or a service treatment record of a similar nature directly from the armed services would not be a Service Department record. So in that instance, the marriage certificate in the hypothetical would not be a Service Department record which would trigger reconsideration and would be more apt for a new material evidence claim.
So service records do not include government records.
Well,
Other government records, say Social Security or another executive department.
Yes, to that extent, the suggestion that SSA records would fulfill Service Department records, the Secretary does not have that interpretation, that the Service Department records would have to come from their period of active service.
Thank you.
All right. If there are no further questions, Your Honors, the Secretary asks the Court to dismiss Appellant's appeal and to affirm the underlying Board decision. Thank you very much.
The confusion over whether records can be submitted with a motion for reconsideration and reviewed by the chairperson or by this court to determine whether it has jurisdiction over a denial for reconsideration come from this court's case, Romero. In Romero, the court specifically held reconsideration based on new and material evidence is separate from reconsideration based on changed circumstances. This court goes through in Romero a long discussion about new and material evidence for reconsideration and ends up holding that any new and material evidence has to be Service Department records under reconsideration for new records. Then there's a second section to Romero that talks about changed circumstances, but found in Romero that there weren't any because his claim for reconsideration was based on new records, not changed circumstances. These are distinct questions. Under even Rule 1000B, because the changed circumstances can be of the variety found in Rule 1000, certain types in certain circumstances, Social Security records would be available or would be reviewable to fit under Rule 1000B if the allegation of reconsideration is for changed circumstances, not new records. And in fact, to substantiate any claim or any motion for reconsideration, the veteran, the claimant, has to be able to submit new evidence. That's what reconsideration is about. Reconsideration is about a decision that is predicated on evidence that wasn't even able to be in front of the board at the time it made its decision, for some reason outside of the party's control. For instance, fraud that results in an allowance of benefits. The VA can't be expected to know when a claimant is lying to them and when they're committing fraud against them. But when they discover that 6 months after the board decision, then what's discovered is that the evidence that the board relied on to grant benefits was false. And so the decision itself is false. Those are the changed circumstances. The changed circumstances are the changed evidence, and that's the difference between a reopened claim and reconsideration. In reconsideration, or in a reopened claim, again, the evidence that is new and material is added to the record and then weighed with all the old evidence. It may change the balance of evidence, not the evidence that's submitted for reconsideration. That's evidence, if reconsideration is warranted, that doesn't just add to the record, it changes the record. Lou Wolfe's divorce decree caused her to lose benefits. The Oklahoma court order that said that divorce decree was void, it was due to Rhonda Matthews' fraud, doesn't just add to the record. It changed the record in 2014. That fraud was there in 2014. It's not the VA's fault that they didn't know about the fraud. It's not Lou Ann Wolfe's fault that she didn't know about the fraud. This court has also already found changed circumstances outside of Rule 1000's strict language. In McCall, the veteran had been denied reconsideration. Before he was denied reconsideration, the secretary admitted that the board decision that was that McCall wanted reconsidered contained 5 legal errors. This court in McCall didn't say that the changed circumstance was an allegation of obvious error. The court went out of its way to say that the changed circumstance was the admission of error by the secretary. So already this court has at least one time reviewed a denial for reconsideration, and in that case ordered briefing after it denied the secretary's motion to dismiss, outside of the strict reading of Rule 1000.
Well, wasn't it obvious? It was the obvious error prong, though, right? In McCall, it wasn't other sorts of changed circumstances. It was a concession by the secretary that there was obvious error of factor law, and we really just accepted that concession. So we didn't recognize changed circumstances outside of the list of circumstances enumerated, but rather we allowed for the concession.
Yes, Your Honor.
Okay.
Yes, and in McCall, the holding was that the secretary's concessions of error in his own decision, I'm sorry, Your Honors, this is not a holding, but this is how the decision ends. The secretary's concessions of error in his own decision constitute changed circumstances of the sort which compel the exercise rather than the declination of jurisdiction by the court. So this court has already found changed circumstances outside of a strict reading of Rule 1000. And in that case, it was 1000A. In Ms. Wolfe's case, it could be 1000A or it could be 1000C. Of the variety rooted in, for example, of the sort, the secretary argues these are restricting, and he's right in part. It does restrict. You can't have a changed circumstance. That was the case in Ngolka, where it wasn't arguing changed circumstances. He just wanted to add evidence of a new exam he had after a board decision. That's not the situation here. He should have done that before the board's decision. And that was evidence better reviewed at the regional office as a new and material reopened claim. But they create a universe, those words. They're limiting insofar that you're limited to this universe in A, B, and C. But they are also expansive because they literally mean, according to Cambridge Dictionary and Merriam-Webster, to not be exactly the same as, but similar to.
Would it have made things clearer and more simple if the situations under which the chairperson could grant a motion for reconsideration, if it was as follows, for the following reasons: the error, new evidence, fraud, or changed circumstances? If there had been that fourth category of changed circumstances.
Yes, Your Honor. I don't know that gets us away from the argument we're having already, because right now this court has said that the changed circumstances are already written in Rule 1000, A, B, and C, but this court determined those aren't the only changed circumstances. There are probably some, and I think it's very rare that you get into a situation where it's not one of those, but it's something very similar to. Unless the court has any further questions, I'll go ahead and take my seat.
Thank you very much.
Thank you.
Thank you, counsel, both counsel. The case will be submitted for decision, and the court is now adjourned, and we'll come down and greet counsel. Thank you.
All rise.